The Committee on Education and Labor will come to order for the purposes of conducting a hearing on the issue of underreporting of workplace injuries and illnesses. The occupational, and I recognize myself for the purpose of an opening statement. The Occupational Safety and Health Act of 1970 requires that the U.S. Department of Labor to collect and compile accurate statistics on occupational injuries, illness, fatalities in the United States. Accurate injury and illness records help the Occupational Safety and Health Administration better allocate its resources, accurately target its inspections, and evaluate the success of its efforts to improve the health and safety of American workers. Every time top officials in the Department of Labor Occupational Safety and Health Administration have appeared before Congress, they have cited declining injury, illness, and fatality numbers to demonstrate their effectiveness in protecting America's working men and women. When Assistant Secretary Falk has testified before the committee whether an OSHA's failure to issue standards to protect workers, OSHA's failure to address the fatal popcorn lung disease, or OSHA's failure to mitigate combustible dust hazards, or OSHA's shortage of inspectors, he has cited a record of low injury and illness statistics. Secretary Falk has essentially told the committee that if fewer workers are being injured on the job, the agency must be doing something right. However, a growing amount of evidence suggests that workplace injury statistics Secretary Falk cites are grossly inaccurate. Today we will hear about the growing numbers of academic studies that conclude that the Department of Labor is actually counting and reporting as few as 1/3 of all workplace illnesses, injuries, and deaths. Some of the undercounting can be blamed on the fact that millions of public employees and self-employed workers are not required to report injuries and illnesses to the Department of Labor. Some of it is a result of the difficulty in counting occupational illnesses like cancer or asthma that may appear years after a worker's initial workplace exposure. However, critics also correctly point to a more significant reason why it is difficult to get accurate injury and illness data. The nation's workplace injury and illness report card is based upon a system of self-reporting by employers. This flawed system gives employers an incentive to underreport injuries. The fewer injuries and illnesses an employer reports, the less likely it will be inspected by OSHA, and the more likely it will pay lower premiums for workers' compensation. There is also mounting evidence that a number of employers are engaging in intimidation in order to keep workers from reporting their own injuries and illnesses. The recent Charlotte Observer investigation on the hazardous working conditions in North Carolina's poultry industry revealed a shocking record of worker abuse and exploitation, often leading to crippling injuries and illnesses. The Observer also uncovered concerted efforts of discipline and intimidate and fire workers in retaliation for reporting serious on-the-job injuries. The Observer found that workers were forced to return to work immediately after having surgery so that the company would not have to file for workers' compensation. I want to commend the Charlotte Observer for their amazing work on this important story on revealing working conditions that remain hidden to most Americans. We learned about workers with shattered ankles and workers whose hands went numb after thousands of repetitive motion, workers who suffered serious knife cuts while on the job, but none of these injuries appeared on the poultry company's accident or injury logs as required by law. We also read about the very same poultry processing plant proudly claiming perfect safety records that were hard to believe if you know anything about the hazardous working conditions. Underreporting of on-the-job injuries and illnesses is not a new problem, nor is it an isolated one. It happens in job sites across different industries and throughout the entire country. As demonstrated by the extensive report released in this committee today, it is a regular practice for the steel workers to avoid detection and therefore retaliation by management by keeping their injured hands in their pockets. This is known as the bloody pocket syndrome. A recent Transportation Committee hearing also revealed similar patterns in the rail industry. And the threats are not just limited to workers. We will hear a testimony today that occupational physicians are often pressured and improperly report and provide inappropriate treatment to injured workers in order to keep the incidents off of the OSHA log. Although there is widespread agreement that workplace injuries and illnesses are woefully unreported, OSHA refuses to recognize that the problem exists. The agency stubbornly refuses to perform thorough audits, which further calls into question the accuracy of the statistics it relies on. Today we will hear testimony from a longtime OSHA official about the agency's failure to seriously address this problem. Some will dismiss record-keeping problems as insignificant paperwork violations, but these infractions are anything but insignificant. Without accurate injuries and illness statistics, employers and workers are unable to identify and address safety and health hazards that ensure that the workers get appropriate medical treatment. We cannot properly evaluate the status of our nation's workplace safety and health laws in this country if we do not start with accurate information. We simply must not allow the lack of information to permit hazardous working conditions to go unaddressed, putting workers' limbs and lives at risk. The purpose of today's hearing is to evaluate the extent and the cause of this problem and to learn what we can do to improve reporting in order to protect workers' health and safety. I'm grateful to all of our witnesses for taking the time to join us today, and I look forward to your testimony.